Good afternoon in New York, North and South America, Brazil. Good morning in California, and good evening in Europe and Africa. And welcome whatever time of the day or night for all who are joining us from all corners of the world. I'm Yael Danieli, founder and executive director of the International Center for MultiGenerational Legacies of Trauma, ICMGLT for short. Thank you for joining today's webinar on the way forward toward a new United Nations Convention for the Prevention and Punishment of Crimes Against Humanity, which is extremely dear to all of our hearts. This International Center for the Study, Prevention, and Treatment of Multigenerational Legacies of Trauma webinar is held to mark the adoption by the United Nations General Assembly Resolution 79/122 of December 4, 2024, entitled United Nations Conference of Plenipotentiaries on Prevention and Punishment of Crimes Against Humanity. This resolution launches a treaty-making process toward a new convention for the prevention and punishment of crime against humanity, which should culminate in a diplomatic conference to be held at the UN in 2028 and 2029. A preparatory committee tasked with the mandate to draft a compilation of proposals that may integrate the text of the draft articles adopted by the United Nations International Law Commission in 2019 is scheduled for January 2026. So we are actually living the history here. Experts from states, NGOs, and academia will discuss the way forward towards the first comprehensive treaty in this critical area of international law for the protection of victims' rights, including gender issues, slavery and the slave trade, crimes against the environment, persecution, and other key issues that the progressive development and codification of crimes against humanity may address. To ensure that ICMGLT's multidisciplinary principles are followed, today's webinar will be co-moderated, mostly moderated. It will be co-moderated by me, but mostly by Dr. David Donat-Katin. I am a clinical psychologist, traumatologist, victimologist, and psychohistorian. I have devoted much of my career to studying, treating, writing about, and preventing lifelong and multi-generational impacts of massive trauma, to ensuring victims' rights, to the rights of future generations, and to reparative justice. David Donat-Katin is an adjunct professor of international law and climate change and human rights at NYU Center for Global Affairs. Since 1995, he has been leading civil society actor in the process of negotiation, adoption, and ratification and domestic implementation of the Rome Statute of the International Criminal Court, or ICC. Formerly Secretary General of Parliamentarians for Global Actions from 2014 to 22, David is a member of the Advisory Council of the ICMGLT. Today's first speaker is Professor Leila Sadat, James Carr Professor of International Criminal Law at Washington University School of Law, affiliated with Yale Law School and chair of the American branch of the International Law Association, or ABILA. She served as special advisor on crime against humanity to the ICC prosecutor from 2013 to 23. In 2008, she founded the Crimes Against Humanity Initiative. She has more than 175 publications on international law, including the ICC Primer, the International Criminal Court in a nutshell. She too is a member of the ICMGLT's Advisory Council. Our second speaker is Dr. Victor Silveira Briosos. Victor holds a law degree from the University of Sao Paulo. He has been a member of the Brazilian Diplomatic Service since 2004. He was posted to the Brazilian embassies in Moscow and Maputo and mission to the European Union. He was also the General Technical Coordinator of Mercosur in the free trade agreement negotiations with Canada. He's currently a legal advisor and sanctions coordinator at the Brazilian mission to the United Nations. Third is Elise Kepler, Executive Director of the Global Justice Center. Elise has over 2 decades of experience working to promote justice for serious crimes committed in violations of international law, including sexual and gender-based violence, before national, hybrid, and international courts. Prior to joining the GLC, Elise worked in Human Rights Watch's International Justice Program from 2003 to 2024. Our fourth speaker is Beata Andemariam, Legal Director at Avaz, The World in Motion. She leads the Avaz team covering negotiations at the United Nations toward a crime against humanity treaty. Beata's advocacy focuses on climate change, the environment, and indigenous rights. She holds a JD from NYU School of Law and an MSc from Oxford University. She has been a lecturer in international law at the New School. Last but not least is Charles Yalow, Professor of International Law and Richard Hausler Chair at the University of Miami Law School. He is a member of the UN International Law Commission, Special Rapporteur on subsidiary means for the determination of rules of international law. He's also founding the editor of the African Journal of Legal Studies, editorial board member of American Journal of International Law, Canadian Yearbook of International Law, and Max Planck Yearbook of UN Law. Quite busy. Charles worked at ICTR, that's the International Criminal Tribunal for Rwanda, and the Special Court for Sierra Leone. What a panel. We have an hour and a half for the webinar, a little more if must be. Each of our panelists will speak for about 8 minutes. Following an interchange among us, I will open the floor to question or brief comment. Both me and David will open the floor to questions or brief comments from the virtual audience. We will then conclude with last words. Please use the Q&A or chat functions and we will do our best to respond to as many questions and brief comments as we can. Feel free to direct your question to a particular panelist or to the full panel. I now have the pleasure to offer the screen to today's moderator, Dr. David Donacati. David, the floor is yours.
Thank you, Yael. And of course, I immediately give the floor to Leila. And we have now more than 75 participants, many more registered. So they will receive the recording. I've seen already a lot of activities from all over the world in the chat. So thanks for everyone for being with us. And Leila, please take the floor.
Thank you so much, David. And Yael, thank you for using your considerable convening power to bring us together as one year ends and another begins, and we begin a very long work ahead of us to turn these draft articles into a treaty. And I thought my job initially was to talk a little about the process, but since many people may not be aware of why we've been doing this, for me for 16 years now, and others for a shorter time, but with great enthusiasm, I thought it might be useful to talk for just a moment about why crimes against humanity are so important, and why the absence of a treaty on crimes against humanity is such a critical gap in the international legal infrastructure. And I'll just say two words, really. It's survivors and victims. And those are the two words that animate what we're doing here and why we are trying to create a new legal pathway for justice and for peace and accountability. And for many of you who are not specialists in international law, you might really not even have heard of crimes against humanity, because the fact that there's no treaty there means that journalists and politicians and scholars write about genocide and they write about war crimes. But there's this huge category of mass atrocity in between something that we call a genocide and something that takes place on the battlefield of war. And these are crimes that can be committed by state actors, non-state actors like ISIS or terrorist organizations. They can be committed in wartime and peacetime. And we have 11 separate crimes within the sort of ambit of crimes against humanity that range from enforced disappearance to mass murder. And so this gap is a gap that we all should have done something about 80 years ago when this category of crimes was created after World War II during the Nuremberg trials. But somehow all the energy went into the creation of the Genocide Convention, an important achievement, but limited in its scope, and the Geneva Conventions. And so here we sit in 2024 with a huge missing piece of the sort of legal infrastructure, the scaffolding that we need to build a better world so we have fewer victims and we can bring justice to survivors. So we can talk a little bit more about what all that means, grosso modo, in the Q&A, but I just wanted to put it out there that this is really important. And the fact that it's important was shown in the General Assembly this past fall, when in a world sort of racked with despair and conflict, I saw people are coming in from Ukraine, which is itself a conflict zone, from Kenya, from Rwanda, from many parts of the world in which there is turmoil. We saw unanimous and enthusiastic applause for moving this new process to treaty negotiations, with one exception, and I'll talk about that in the Q&A. But it was really quite a moving experience. I flew to New York multiple times this fall to be physically present, to see if I could literally physically move this treaty out of stagnation. So Yael, with your permission, and David, I did a few slides just because the process is a little bit technical, and I'm happy to share the slides with people afterwards. I can send you a PDF. So I'm going to share my screen. Can everybody see it?
Yes.
Yes. Okay. So just a few slides, and you can see this graphic, by the way, was a graphic I created for the project 16 years ago. It's obviously moving from the sword to the word, from imprisonment or atrocities to peace. And that is what we hope for. So I'm going to talk a little bit about the chronology. And the reason I think it's useful at this juncture to still look at the past and not just at the way forward, because we are going to focus on the way forward, is there was a lot of work done over the past 16 years that we don't have to redo. I suppose is what I'd say, because some of it was done by the International Law Commission, some of it was done by academic experts. But basically, this project where we are today started with an academic project at my university, guided by some thoughtful individuals. And then that was passed sort of as an academic offering to the International Law Commission. And I'm so happy Charles is here today. As a member of the commission, I have fond memories of seeing his advocacy and hard work in Geneva, and I know you'll be thrilled to hear from him yourself. And then what happens is the ILC gives its product to the Sixth Committee. The Sixth Committee worked on it pursuant to a resolution 77/249. It then finally tipped it out into the General Assembly, and now we're looking from 2025 to 2029, a pretty long timeline, friends, right? 21 years from start to finish for this project. But we can get there. So the academic project, and I'll put all these links are in the slides. Some of you might recognize some of these people. I was younger then, a little bit, but I want to point out this is Sharif Fasyouni here, and Sharif was, in a way, I think, David, he was our father. He was the chair of the drafting committee at Rome, and I worked with Sharif on many, many occasions. And he drafted sort of our proposed convention. So we were able to literally draft a convention and hand it to the international community as an offering. That treaty is still up on the website and has a lot of really interesting ideas in it as we continue to work. And then, of course, it went to the International Law Commission. This is the special rapporteur who's been invited to the meeting. Charles, this picture was taken before you joined the commission. I'm sorry, we'll have to Photoshop you in. This was in 2013 when the commission just began its work. And I won't go through this, but the reason I have these slides that do have some technical detail is I want all of you to understand how painstaking the work was on this process, right? 3 years of elaboration by academics, years of study, then the International Law Commission itself, working really with getting comments from governments every single year, develops a first draft, comments come in, and then it develops a second draft. And the problem is that the second draft, what they call their second reading, and Charles may want to add some technical information to this, then goes to the Sixth Committee. It goes to the General Assembly, and the Sixth Committee is the legal committee of the General Assembly. And guess what happens? Nothing. No, actually, some fantastic speeches. Austria stands up and says, we're going to host this diplomatic conference. We're all tweeting it out and cheering it, or nowadays we would be blue skying it out, I suppose. I left Twitter. And it stalled. And I won't go into all the reasons, but basically, the first year in 2019, you could have said, it kind of came upon states. Some states really hadn't had time to study it. It's true, the commentaries are quite long. So you could have sort of excused 2019. 2020 was the pandemic. And I will say a huge thing for all you civil society folks civil society in 2020 and 2021 could not get into the building. And I think that was a huge reason that it stalled. Because in 2021, when states were reactivated, the pandemic was basically over, the UN had not adjusted its working methods and we still couldn't get into the building. So you'll see at the end of my presentation, I have I've been tracking this since 2013 when the ILC started its work, and the increase in state support every year has been significant. But because the Sixth Committee works on the process of something called consensus, meaning that any state can kind of put a block on something, it basically gives each state a veto. It's not really supposed to work that way, but that's how it ended up working. A couple of states, particularly the Russian Federation and China in 2021, said we're just not ready to go forward. They weren't the only states, and we'll talk about that. But the consensus process was really bogging it down. So in 2022, Mexico and the Gambia, and the reason I think the history is important is for those of you not in the global north, this was a global south-led process. It's a pretty exciting development in international law. For those of us who think that international law can't be made anymore, it was Mexico and the Gambia with a strong core group of states that actually produced this resolution 77/249 to unstick the process in the Sixth Committee and to allow the committee to retain the consensus, but actually start discussing the elements of the draft articles that the commission had submitted. And so after that, they this year, because they were supposed to take a decision this year at the end of the 2-year process, a zero draft was produced again with Mexico and the Gambia leading the charge, deciding to convene a diplomatic conference. Now, I have to say, I cried when I saw the operative paragraph 4 because we had never seen this before. We'd heard talk about it from states, we'd heard a lot of conversations, but this was the first time it really had been committed to piece of paper. It started with about 60 co-sponsors. By the end, we ended up with a resolution supported by 99 states. But what happened was then the consensus tradition kind of came in, and we had some very dramatic last minute negotiations. The negotiations involved extending the timeline, restricting the capacity of civil society. Some of it was very useful in the sense that they had not really foreseen how the treaty drafting process would work, how it would build on the ILC draft. And so creative proposals were coming through to be added to the zero draft. But what we ended up was with this resolution adopted on December 4th. And Yael, this is the original number. I don't know if the final number was different, so correct me if I'm wrong. I just pulled it up off the website. But
122.
yeah, I know they renumber them sometimes. So this was the one that was adopted that day. So I'll change that to 122 before I send it to you. But basically, we have a complex multi-year process in front of us now. And in 2025, nothing formal will happen in the way of treaty negotiations. The first time we have something happening formally is 2026, which is the convening of, quote, a preparatory committee. And somewhat confusingly, there's going to be a working group that meets during the entire first session of the preparatory committee. And we're not 100% sure yet what that will look like. And it's important for civil society participation, which is why it's not clear if those are basically the same bodies, just different people, or how that's going to work. But in any event, the idea is then governments on April 30th will have the right to formally put forth proposals for amendment. So for those of us thinking about the draft that so excellently was produced by the Commission, any additions or modifications would have to be submitted by governments. But of course, there still can be changes even during the conference itself. Another PrepCom in 2027, and 2 3-week diplomatic conferences, one in 28 and one in 29. We can talk a little bit about some of that. The CSO participation is a little confusing. ECOSOC organizations are definitely accredited to the PrepCom and the conference. The working group, maybe, I don't know, because we don't know if the working group is really a separate thing, and it's not clear about other non-ECOSOC organizations. I just have this little chart. You can see state enthusiasm over time grew exponentially with respect to this project. And at the end of the day, I think that's why we saw after the vote was taken in the Sixth Committee on November 22nd, and trust me, it was really challenging all day long. We saw Iran, Eritrea, states that had not been supportive of this process saying we are excited and happy that we joined consensus and happy that this process is going forward. Of course, the devil's always in the details, so we want a good treaty, not just a treaty. There are lots of regional statements. I put some additional resources here. I think I'll stop there. I might just say one other word, which I did say which state was the biggest problem, and that was the Russian Federation. The Russian Federation dissociated from consensus in the Sixth Committee, and it dissociated from the adoption of the resolution on December 4th. And there is no doubt that the extended timeline and some of the last-minute amendments in the resolution that was finally adopted are a result of sort of if I put it kindly, Russia being a bit of a chaos agent, because I was there during the negotiations, and at one point they said, we have an agreement, and states were sending around pictures of white smoke coming out, like we've decided, the Pope's been chosen. And then all of a sudden they said, no, we have to go back to Moscow for instructions. And it turned out they couldn't join the consensus. And so there was a lot of emotional turmoil, but I'm super grateful both to my civil society partners, many of whom I see here, Beata and Elise and Yael, David, and to the International Law Commission and everybody else who really put shoulders to the wheel to get us this far. Now we have a long way to go, and I'm going to turn it over to others to talk about where we go next. Thank you so much.
Thank you so much, Leila. And in fact, you mentioned the role of the CSOs, so civil society organizations. So we have two of them. And let me mention maybe one person who really, together with you, Leila, involved me into this process many, many years ago when still the International Commission was working on a draft. And it was Ugo Relva of Amnesty International, who really played the role of facilitator. And then the NGO who really played a central role in New York in helping us to understand what was going on has been historically the Center for Global Justice. So who better than Elise, their new executive director, who has, by the way, an incredible background on working in and on Africa for many years. So Elise, please take the floor.
Great. Thank you to everyone who has joined this call. It's great to see, I think we're at 80 participants, to see the level of interest in these issues. I want to encourage people while I'm speaking to post in the webinar chat if you're finding the information at all inaccessible or you have other questions. This is really an opportunity for people to get up to speed. And I want to thank Leila for starting out with some kind of core information about crimes against humanity. Leila has given fantastic background and about the process. And what I want to do today is talk about some of the efforts that Global Justice Center and a number of other gender justice experts have been working to do to see integrated into this treaty. Global Justice Center is a feminist human rights organization, and we have a mandate to use international law to advance gender equality. We do that with a focus on two main areas. One is reproductive autonomy, which we will not focus on in this discussion. The second is justice for atrocities involving sexual and gender-based crimes. It's in this second area that we became interested in trying to work on the Crimes Against Humanity Treaty. And why is this? For one, we knew that having a treaty on crimes against humanity would close a legal gap, but in particular, a legal gap related to codification of certain gendered harms. One crucial one is gender persecution. So the persecution on the basis of gender is recognized as a crime against humanity, but is not otherwise in the Genocide Convention, the Geneva Conventions. And so just by having basic codification of crimes against humanity, we would already be doing a better job in shining a light on and therefore increasing prospects for prevention and punishment of gendered harms. In addition, we saw an opportunity with the creation of this treaty to take fuller account in international legal instruments, in treaties, of a fuller range of gendered harms. And some of this goes back to the idea that when the International Criminal Court was created, we understood things at a certain level. And since that time, there's greater understanding and greater recognition in international law of crimes that have gendered impacts or relate to harms on the basis of gender. So in recognizing that, this was an opportunity to kind of transform the international criminal law landscape to prevent and punish gendered harms. And so last year, prior to my coming on board, but having the opportunity to work with these proposals as soon as I did, Global Justice Center worked with a number of groups and experts to develop proposals that could be considered by states to make the Crimes Against Humanity Treaty what we call gender competent, intersectional, and survivor centric. And these proposals relate to additional crimes, but then also additional ways of thinking about and interacting with provisions around victims. So I want to walk through each of these with just a sentence or two. We could have a whole session just on these proposals. In fact, we just did at the recent gathering of the International Criminal Court Assembly of States Parties. But the hope is that as I tick off these proposals, you'll get a bit of a sense of some of what we're pushing for. And then I'll also put in the chat a website that we've been maintaining where you can access more details about each of the proposals. And in fact, there is a policy brief, like a 5 to 10 page paper on each of these proposals. So I'll start with the first proposal is a term that probably many on this call have now heard reference to because recognition of this harm has been gaining steam globally for the Crimes Against Humanity Treaty, but also beyond this treaty, and that is the crime of gender apartheid. So many on this call are probably familiar with the concept of apartheid, racial apartheid, coming out of the experience in South Africa. Activists and victims, survivor networks have come to seek to use the term gender apartheid to recognize that structural systems of discrimination that are happening on the basis of gender can be recognized with the use of the term apartheid and not solely restricted to race. So the proposal seeks to have gender apartheid included in the convention as a crime against humanity. And this proposal has particular resonance with victim communities in Afghanistan, which have really led the charge in having this crime recognized. So that is the first proposal. The second is to recognize in the treaty the crime of forced marriage. Now, this is a crime that has been recognized in case law internationally, including the Special Court for Sierra Leone, a court that I tracked quite a bit, where in the conflicts in Sierra Leone, there was the experience of what people called bushwives, women, usually women taken to be quote unquote married or serve fighters in the bush. And case law has recognized this as a harm, as a particular crime, but because forced marriage was not recognized in other statutes, it was charged under the idea of other inhumane acts, which is a crime against humanity. The challenge with that, better than nothing for sure, but the challenge with that, I think we know that when things are not expressly identified, it is harder and rarer to see it prosecuted. And so by having explicit recognition of the crime in the Crimes Against Humanity Treaty, we hope to increase the prospects for prevention and punishment. So that's number two. The third is the crime of the slave trade. And some of you may know that enslavement is a crime, recognized crime. It's recognized in the draft proposed Crimes Against Humanity Treaty. But the lack of a specific crime of the slave trade risks omitting certain key harms related to slavery that can happen where there is trading, there is trafficking, but perhaps a person does not end up enslaved, and to recognize that harm and to capture it. And of course, while the slave trade maybe on its face is not as clearly a gendered harm, what we know is that a lot of times the trading is really based or has been based in the past on particular aspects of people, what people can different attributes related to gender, whether that's childbearing or heavy labor. And so we see it as related to this category of what we call our gender justice proposals. The fourth is recognizing a category of harms called reproductive violence. And I think at this point, under anyone who's following international law knows, I think at the outset, it was really rape as a weapon of war, and then it expanded to recognize sexual violence. There has been increasing expansion and recognition of different harms related to gender and sexual violence, but we see a value in recognizing expressly a harm that can relate with interfering in people's reproductive autonomy that may or may not be in parallel or combined with a harm involving some kind of sexual aspect. The example I like to give, just to make it really clear for people, is the example of fighters, militia fighters in Colombia who have been forced to take contraception so they are able to keep fighting. That would be an example of reproductive violence. There are a couple forms of reproductive violence that have been expressly recognized in the ICC's Rome Statute, forced pregnancy and forced sterilization. But there is a much wider category that has not been expressly recognized. And going back to this idea that when we help clarify the specificity of harms, we help ensure greater chances for prevention and punishment. So that's 4 of the proposals. The last proposal talks about ensuring ways in which to ensure that this treaty, both in substance and in process, is victim and centered, survivor centric. And so it includes a couple things. One is making sure that the definition of victims is expansive and robust, including, for example, recognizing family members of those who have been physically harmed. Also making sure that provisions for reparations are strong and encompassing various aspects as need to be. And then also thinking about ways to integrate survivor networks into the process to create a treaty so that it's not so distinct or abstract for those who will be affected by the crimes. And we are looking at ways to encourage governments to consult survivor networks on how they're influencing this treaty process. So those are the proposals. I should say that Global Justice helped shop these around and disseminate them widely to states and also civil society groups. And in the coming year and years, now that we're going to treaty negotiations, we're really looking forward to the chance to dig in and look to mobilize a cohort of champion states on each of the proposals who can take this forward and really press ahead with them, and then to increase recognition and awareness of these proposals among a much wider group of civil society. And in addition, we will be doing or looking at doing a more comprehensive, I probably need to wrap up. Is that why you're putting up your finger? Yeah, I am wrapping up. Yeah. A more comprehensive gendered analysis that doesn't just look to specific proposals, but shows ways in which the treaty provisions may need to be tweaked to not have potential negative effects with respect to gender or kind of embedded discrimination, both in language and interpretation. So we're excited to continue to keep contributing in this way. And thanks for the opportunity to speak on these issues.
Thank you, Yael. Thank you, Yael and Elise. Sorry for putting Elise before Victor, but I got really carried through by Leila's enthusiasm on the civil society role. So now we are doing a step back into the state role, which is, but after, I think, Victor, your work now is easier because Elise essentially depicted what will happen between now and maybe January, April 2026, where a lot of new proposals will make this process even richer than it has been so far. So, Victor, I really look forward to hear from you regarding the Brazil's position. And let me tell you, by reading the press release that was issued on the UN website, you are featured as one of the most important states, as the United Nations press release in question on the 22nd stated that Brazil's representative observed it is high time the United Nations concluded a convention on prevention and punishment of crimes against humanity to be applied by national court, a glaring gap in international law. So please take the floor. I think your statement has been already cited universally, and we look forward to hear from you.
Well, thank you very much, David and Dr. Yael, for the invitation, and thank you, Professor Sadat and Elise, for the enlightening presentations. And with regard to the glaring gap in international law, it's no surprise that I agree with this statement. When I was invited to participate in this webinar today, I thought how I could add value to such an eminent panel. And the first thought that came to my mind was that I should give the perspective of a member state, more precisely the member state I represent, Brazil. Our perspective on how the General Assembly arrived at the decision to convene a plenipotentiary conference for the negotiation of a convention on the prevention and punishment of crimes against humanity. Also, our expectations for the future convention. Although the views of the academia and civil society inform our considerations, it's natural that our views do not always coincide. Pragmatism sometimes prevails over idealism in multilateral diplomacy, which is, so to speak, the realm of the possible common ground given the plurality of views of member states. Some organizations of the civil society and even member states may be disappointed that the conference will only start in 2028, while a convention on crimes against humanity is long overdue and victims can't wait any longer for it. This wait is the price we paid to have a consensual resolution to make it sure that every member state felt included. Brazil sees the consensus in the Sixth Committee, which approved the resolution, not as a barrier to protect it from decisions that might not be completely in line with our national interests. We consider it, especially in this case, as a means to ensure that the future convention will achieve universality. A convention with limited adherence won't be effective. Some member states felt the need for more time to hold national and regional consultations in order to be able to present drafting proposals, and Brazil respects that. By the way, Professor Sadab, this is the main reason why there will be a working group of the Preparatory Committee in 2026. The quest for universality was the reason why Brazil and many other delegations insisted on consensus. One of the most contentious issues during the resumed sessions that the Sixth Committee had in April 2023 and 2024, and the regular session that ended in last November to discuss the resolution on crimes against humanity was whether the International Law Commission's draft articles on crimes against humanity should be the basis of a future convention. That's why some states, on the one hand, wanted additional time to prepare drafting proposals. Others, in particular parties to the Rome Statute, have concerns over possible attempts to depart from the ILC draft articles. Their concerns are mainly linked with, but are not limited to, the draft article on the definition on crimes against humanity, which is very similar to Article 7 of the Rome Statute of the International Criminal Court. Brazil deems the draft articles as a good basis for the convention, but there is always room for improvement. For Brazil, the prohibition on crimes against humanity as acts perpetrated in the context of a widespread or systematic attack against any civilian population is clearly what we call in international law jus cogens. That means that they are mandatory and universally accepted. That this prohibition is mandatory and universally accepted. The first paragraph of Article 7 of the Rome Statute and of its equivalent ILC's draft Article 2 enumerates the same conducts that amount to crimes against humanity, with a small difference in the connection element in the crime of persecution. Both lists build on the crimes against humanity referred to in the Charter of the Nuremberg Tribunal and the special proclamation on the establishment of military tribunal for the Far East. We can say that they have the same crimes against humanity later mentioned in the statutes of the International Criminal Tribunals for the former Yugoslavia and Rwanda, even if the conducts referred to in the Rome Statute and the draft articles are spelled out in a slightly different, sometimes more detailed manner. Therefore, there are compelling reasons to argue that at least the chapeau and the several paragraphs of paragraph 1 of draft article 2 on the definition of crimes against humanity reflect customary international law in general. My impression is that the opposition to this idea derives more from the fact that those provisions were codified in the Rome Statute, which bounds 124 state parties, but not the international community as a whole, than from their content itself. When it comes to the description of the conducts in paragraph 2 of the ILCs and the Rome Statute article on crimes against humanity, most of it seems to codify already existing international law. However, persecution and enforcing disappearance may be exceptions. Persecution was a standalone crime in the ICTI's and ICTR's statutes. The requirement of the intention of removing from the protection of the law for a prolonged time has made the ILC's definition on the crime of enforcing disappearance more restrictive than the one in the International Convention for the Protection of All Persons from Enforced Disappearance. As regards to gender-related crimes and enslavement, civil society has understandably been calling our attention to the need for international criminal law to evolve with a view to the prevention and punishment of conducts that reach the threshold of gravity of a serious crime under international law. In this sense, Brazil is taking serious consideration the proposals to include gender crimes such as gender apartheid, forced marriage, and slave trade in the future convention, which Lisa already explained about. As for definition of gender in paragraph 3 of the Rome Statute, absent in the draft articles, is Brazil's view that it's not in accordance with its current meaning under international human rights law. Even for those who may disagree with us, and this definition, for those who don't know, it limits gender to the female and male sexes. Even for those who may disagree with us, with our more progressive approach to gender, I believe that they must consider that we were far from having a unified opinion juris, legal perception in the Sixth Committee in this respect during our discussions in 2003 and 2024. Therefore, we support the IOC's pragmatic approach to eliminate from the draft articles advisive definition, which in any case should be an incidental, not a core element of the future convention. Brazil has suggested some adjustments to the draft articles. We believe it's important to reinforce the legal certainty of some provisions. Besides suggestions I already mentioned on the description of certain conducts and the inclusion of new ones, others are related to mental elements, the primary jurisdiction for the prosecution, and safeguards connected with extradition. If there is time and interest, I will be happy to elaborate on them during the debate. Thank you.
Thank you. Thank you very much, Victor. You really cover so many thematic issues, but certainly you highlighted the fact that the ILC work in a very pragmatic way. So already made some choices that may help speedy and good negotiations, but we don't give the floor now to Charles. He's going to remain the last speaker, even if he's a member of the ILC, because before him there is Bieta, who's going to introduce us the issues of the crimes against the environment. And let me just say that AVATS in September issued a petition that was signed by more than 500,000 people in all regions of the world calling for this treaty to be negotiated. So AVATS is probably the biggest bottom-up group representing civil society in the world in support of this of this campaign. Vieta.
Thank you so much for that introduction. And thank you to the ICMGLT and Dr. Danielle and Dr. Catton for hosting this wonderful event and inviting me to it. And I'm so glad to be able to make a small contribution. For those of you who are not aware of AVAZ, we are a global advocacy organization, and we bring the voices of our nearly 69 million members worldwide to decision makers through online petitions, media work, advocacy meetings. We are 100% funded by our members. That means we don't take any money from companies, foundations, governments, so we can be completely unbiased and partisan in our efforts, which is really terrific. We consult our members before we run any campaigns because we are a member organization, and we rely on the work of partners and allies like Global Justice Center, and they lead the conversations, and we try to support in whatever way we can. So I'd like to talk a little bit about the support that we've given to this process so far before I discuss our interest in the addition of environmental destruction. As David mentioned earlier this year, we released a petition calling on states to move the convention out of the Sixth Committee so it can be one day in the real world. And we felt it was a very important time, and we've been told it was a very important time to try and get the world's eyes on this, because I was listening actually to a podcast that Layla was on, Asymmetrical Haircuts, and they sort of referred to this process as dark and murky legal spaces, which I think is where a lot of people perceive these efforts to be. So some of our work is about bringing the messaging to our community members around the world. We have more than 190 countries represented, in clear, easy to understand language, but that of course is not talked down to our members, and to tell them how important this convention will be to protecting vulnerable women, girls, Indigenous people, people with disabilities in wartime, but also in peacetime, which, as I think Layla noted, is a huge gap in international law right now. And crucially, that they had power to help move this along because they were the constituencies of the governments who were going to eventually meet the consensus to move it out of the Sixth Committee. So it actually was popular input. And as David mentioned, our petition got to 500,000 signatures. We're very proud of that. We also gathered some messages from members in English, French, Portuguese, Japanese, and Malaysian, and conveyed those to their state representatives. And I'll just take 1 minute to read part of one message where you can see how this has really landed with our membership. Bem from Australia said, "We have a once-in-a-generation moment to stand up against oppression. I urge you to work towards a comprehensive treaty dedicated to acknowledging, preventing, and punishing these atrocities. Our progress as a species relies on your integrity in this moment. Please rise to the occasion and represent the wishes of 500,000 citizens globally who do not have the power you have, but regardless, represent the people you are trusted to represent." So I think that's really a testament to how much this messaging can land with people when it is conveyed well. So as David mentioned, AVAZ as an organization is deeply invested in environmental protection on a number of different fronts, frankly. And I think this is one area where we see some development and some contribution to move the international legal framework forward. One aspect of crimes against humanity, like the threshold issue of a crime against humanity, is that it should be widespread or systematic. Environmental destruction, almost by definition, is going to be widespread or systematic because it's very hard to geographically rein in the effects of environmental destruction. And it's also difficult to temporally rein in the effects of environmental destruction. You'll see one notorious example from decades ago was the US's use of herbicides in Vietnam. And the effects on the population, on the civilian population, have lasted not just in the 60s and 70s when the war was happening, but generations up until today with increased cancer rates and genetic issues. And so, when you have an attack that is mediated through the environment, it almost, like I said, by definition, will sort of meet that threshold of widespread or systematic. However, the current draft articles do not include environmental destruction. I think, as Layla mentioned, that was because of it. It was based on the Rome Statute, which also does not have it. But we see that in the 25 years since the Rome Statute was drafted, that there's been a great expansion in focus on the environment and the protection of the environment, not least because of climate change and how climate change has already, just as a baseline, pushed people to the brink in many situations. If you were vulnerable before the effects of climate change, you are much more vulnerable now. And so changes to your environment are going to have, increased ramifications to you. Couple that with population growth and resource depletion, and we really have a recipe for disaster. And so we've seen the human right to a healthy environment take shape in, the American Convention on Human Rights, San Salvador Protocol, the African Convention on Human People's Rights and Shrines of as a Right. We see it in the jurisprudence of the European Court of Human Rights. This year, we've had major tribunals, the ICJ, ITLOS, which is the International Tribunal for the Law of the Sea, and the Inter-American Court consider what are states' obligations with regard to climate change and pollution. Some of these decisions we're still waiting on, but hopefully they will further solidify this right. And I think that's important because when you have a human right, you sort of have a glide path to a crime against humanity in a way, because when you have a mass violation of that right, it sort of begs the accountability question. So the fact that this is becoming a very well understood and well-defined human right, I think, naturally raises the question, well, what happens if that's violated? Additionally, humanitarian law and international criminal law is increasingly catching up to the environmental issues. Within the last decade or so, the Office of the Prosecutor at the ICC has issued policies in which the office has said that they will look at environmental destruction when considering case selection and prioritization, as well as in their preliminary investigations. And just this year, sought proposals for how to further green their work on international criminal liability. So a definition is kind of already there. It kind of already exists because we have an existing convention on environmental modification in wartime. It's the NMOD convention. I'm not going to say the whole name again. But basically, a definition could look like, environmental destruction is widespread, long-lasting, or severe destruction of the natural environment as the means of destruction, damage, or injury to a civilian population. That is Avaaz's, having a standalone enumerated crime is Avaaz's stance. As Elise pointed out, there is this catch-all of other inhumane acts. But for the reasons that she said and more, it's not particularly the right place. It's better than nothing, of course, as I think Elise said, but it is not the right place, we think, for this crime. That is a place for crimes that are not really within contemplation right now, that we have not really encountered, something that could come in the future. As Elise pointed out, it is harder and rarer to prosecute crimes that are not listed. It also has the benefit of putting states on notice that this is a crime, and also giving them their due process to know that it is a crime before they violate it. And we've already seen some support with states to add some dimension of the environment to the convention in their statements to the Sixth Committee. We've had states like Sierra Leone, Eritrea, and Burkina Faso mention that there's no coverage right now for the environment, either through natural resource depletion or through environmental destruction. So looking forward, obviously, the movement of the convention out of the Sixth Committee was a huge step forward. And we are working with a very long timeline to the next, to 2029 and an eventual treaty, which can be advantageous because we can continue to lay the groundwork to develop that body of law, both on an international level, but also on a municipal level, national legislation, state court jurisprudence, in order to create that foundation, as well as continue to engage with people around the world and explain to them why this is so important, why they should care about it, why it should include the environment, and also get more states on board. Right now, we've only seen a handful of states that are very, interested in this or have mentioned it on their own. And we really need many more to do so in order for it to become a reality. So thank you very much. I hope that wasn't too long.
Thank you, Beata. This is excellent. And we have a lot of patience. We had an ILC draft statute on the ICC in 1950, then 1954, then 1994, and then a diplomatic conference 98. So we can, let's say that the starting date of this was what Leila told us, 2008. If we finish 2029, it's still less than a half of what it took to create the International Criminal Court. So let's be optimistic. And our final speaker actually sits in that very institution that drafted these draft articles that, as I think Victor said, more or less represent already a very good balance point between certain needs for progressive development, maybe other needs for universal support. So, of course, Charles, you are entitled to also speak in your other capacities, because I've seen you recently at the Assembly of State Parties in many side events, speaking on many topical issues also that are related to the crimes against humanity that tragically we are all witnessing nowadays. So please take the floor.
Thank you very much, David, and thanks, of course, to all of you as organizers for inviting me to be part of this conversation. Basically, I was asked to comment on this particular topic, and I should preface my remark by making a broad observation that this is a significant development, not only for the specific topic of crimes against humanity that we're dealing with, because of also what it says about the potential of the relationship between the Commission and the Sixth Committee. This is a point that hasn't been raised, but I want to highlight it because for the better part of international law's development, there has been a strong symbiosis and relationship between the Commission and the Sixth Committee. I know that we're told that this is a multidisciplinary audience, so I don't want to get too legalistic, but just to flag that, as Leila pointed out earlier, the legal committee of the General Assembly basically deals with all issues of international law. And essentially, in relation to the aspect about promoting international cooperation between states in the political field, states in their wisdom decided to establish a technical expert group of lawyers. At the time, a smaller number than today. Today, 34 international lawyers from different parts of the world. And they basically work under the direction of the legal committee and report to the legal committee. And as a result, we've had a significant modern legal architecture that touches on basically all aspects of international law because of that successful relationship between the technical experts who are independent experts serving essentially the role of being the lawyers in the room, so to speak, without the political interest, but then ultimately being accountable to the states in the Sixth Committee. So there has been a long success story, so to speak, between the two bodies, but that came to a halt a while ago. This is about 2001. And much that has come from the Commission has not been taken forward. So I just want to underline that what has happened now in the Sixth Committee, taking this decision to take forward the ILC draft articles on the prevention and punishment of crimes against humanity, sits in that wider context of reopening, if you will, of the conversation between two critical bodies that are fundamental to the development of modern international law. Second point, specifically on the crimes against humanity articles, and I'm glad that Victor already spoke from the perspective of states and underlined this idea of pragmatism. Pragmatism is what drove the discussion in the ILC. I think Leila alluded to being in the room when we were having some fights about all kinds of issues. And I have to say, the Commission's work is the Commission's work. Sometimes the members join the consensus, but they're not necessarily happy with everything that's in there. And I have to say that I've been one of those members who, partly because of my background in international criminal law, the work in the tribunals and so on, I wanted more, right? But you need people who want more and people who want less to meet in the middle. And when it comes to the definition, the Commission took the position that it ought to basically use the definition that's been agreed by states, especially in the Rome Statute, and with some minor modifications. And I have to say that I was very proud of the Commission when it comes to some of the elements that Elise was highlighting, for example, the gender aspect, and I think Victor spoke about this as well, where the Commission responded. You will see basically two aspects to that story. One part of it was the definition that was proposed to say in the first reading text actually had the element of gender as defined in the Rome Statute, Article 7. And essentially, it said what the gender is basically when you look at this, as defined as essentially when you have a man and a woman. And it's a sensitive point in the 6th Committee for States. But in the Commission, we could find agreement very quickly, and the Commission decided in response to the request of an overwhelming number of states to delete that part of the definition. So it did not include that aspect of the Rome Statute, essentially by demand of the states themselves. Now, what is interesting, if you fast forward to the debate in the 6th Committee, there are states that are very divided over that particular question, including states in the African region, but also in other parts of the world that prefer to retain the Rome Statute definition. So that's an interesting fault line that we'll see for what then becomes this idea of potentially modifying the Rome Statute definition and then effectively adjusting it to include potentially new crimes. So this is an important point to highlight, that at the level of the ILC, the Commission listened to the states in terms of what states said as, if you will, a passe definition that refers to gender as being to the two sexes, male and female, within the context of society, which is, by the way, one of the few elements where the Vatican and Islamic states could agree when the negotiations were happening in Rome concerning Article 7, what basically is Article 7 today. Now, having said that, we know that there was a strong explanation by the Commission in terms of how this has evolved, including in the policy papers of the Office of the Prosecutor at the International Criminal Court, the development of subsequent guidance document by the CEDAW Committee that dealt with the question of gender, and ultimately that was in 2010, and in 2014, the policy paper on sexual and gender-based crimes adopted by the ICC prosecutor that basically decided that it would use a more updated and human rights-oriented understanding of what gender is. It, of course, will be a challenge for states in terms of dealing with the balance between including this and potentially dealing with new proposals for additions to the definition. And on that aspect, let me just flag a couple of things. I heard, of course, and Elise laid this out very well, about the proposal to deal with gender apartheid, the forced marriage as a crime against humanity, the proposal by Sierra Leone to address slavery, which is one of the missing pieces. It's missing because it was not included in the Rome Statute crimes. And of course, this idea of environmental crimes. And it's interesting that Data, you focus on that bit because there's sort of like parallel movements around environmental crimes now, both in terms of Article 8, which is the war crimes provision in the Rome Statute, where there's a discussion about adding ecocide as a consequence of dealing with environmental concerns. But in respect of crimes against humanity, a concrete proposal by Sierra Leone to add environmental crimes alongside the idea of slavery to accommodate some of the challenges that the international community is facing today concerning the environment. So with those ideas, I think part of from the point of view of civil society, what would be important is to now be very strategic and organized in terms of what it is that would happen in the process. Leila laid out the multiple stages of the process and what is expected to happen. I think it is an interesting moment for the international community to be negotiating a convention on crimes against humanity. What you don't want is a convention that falls short of what we have at the moment. This is my big fear. And I think the only way you can avert that is for civil society to be very organized from all the different parts of the world to actually try to influence the negotiations. Interestingly, at the state level, there are many friendly states that are still progressive, that are thinking about developing the law in a robust way. And I would have to say that there are some key planks of the instrument that, in my view, that came from the ILC that ought to be retained. So obviously the aspect about prevention of crimes against humanity is very important. That had been developed on the back of the provisions in the Genocide Convention as interpreted by the International Court of Justice in several judgments at the International Court of Justice. This is going to be important as a piece. The aspect about criminalization under national law, the aspect about mutual legal assistance and extradition, those are important components that would have to be included in my view. And ultimately, of course, there's that big, if you will, elephant in the room about what the international community would do when it comes to the question of immunity of officials when it comes to crimes like crimes against humanity. I will just underline that of all the core crimes, crimes against humanity is the broadest category available. And part of the reason is this element of other inhumane acts, which is where the law has grown. This is where forced marriage was developed out of the Special Court for Sierra Leone, and where if you step back, war crimes, you require an armed conflict. Genocide is very difficult to prove. So in my mind, it's the most important crime because it's very broad. when it can show the elements of widespread or systematic attack against the civilian population, they actually have, you know, the possibility of success in prosecuting the cases. And we've seen empirical work that shows that, in fact, when prosecutors had the choice, they would go with crimes against humanity over the other two crimes. So this is just by way of underlining the significance of this process. And I'll just end, because I've just gotten past the 8-minute mark, with this point about the dispute settlement provisions and the absence of a monitoring body. The dispute settlement clause in the Genocide Convention allows something like what has happened, where the Gambia could invoke this treaty and take another state, Myanmar, to the International Court of Justice. States are now, if you will, waking up to this possibility, and quite a few of them are very nervous about this. So my fear is now that you have the possibility of a negotiation, state would actually try to undo that system, because they see now the possibility of being held to account by other states, which was something that they themselves envisaged in 1948 as essentially becoming a little bit of a threat to their national interests. So this is one element that I think is important to watch. And secondly, and I will be remiss if I didn't raise this, the absence of a treaty monitoring body, some kind of mechanisms to hold states to account in the ILC draft was a choice that the Commission made for understandable reasons. I disagree personally with that reason, but my point is to say that now is an opportunity for civil society to be galvanized around this. There are a number of states that have raised this, that you would have a treaty that basically doesn't have much teeth if we had actually had a treaty without some kind of monitoring system. I know that monitoring mechanisms are a little bit complicated and sometimes a little bit sensitive because of resource issues, reporting requirements, and what have you, but it's not to say that where there's a will, there's not a way. So I'll leave it at that. Thank you very much. I look forward to the conversation.
Thank you so much, Charles. And I think we have limited time to debate. So what I would do, as Yael recommended, okay, Yael first, and then we open the floor for commentaries among yourselves.
Yeah, I would like to add to these rich points that every crime considered by this treaty is multi-generational and has multi-generational implications and should be stated as such. It's true of the genocide also, but this is the one we're looking at today. And so I wanted to make sure
Thank you.
Nation is represented in its essence in this discussion. Go ahead, David.
And this is really in line with also Elie's commentary on the victim-centered, survivor-centered approach.
Of course, Elise and I, we will meet exactly on that, since everything we do is victim-centered. And
maybe I would give the floor to Leila and then Victor first on certain issues. For example, Charles made a fantastic presentation on the relationship between the ILC and the Sixth Committee, and this is the first time the Sixth Committee takes action. But maybe on the issue of immunities on certain other aspects that have not been addressed purposely by the ILC. I don't know if Leila, you want to add something, if whether that's already a point of sort of compromise.
So one of the reasons I backfilled a little bit to our academic project that started in 2008 is academics and civil society are operating without the constraints of political constraints, basically. And so the perspective that we took in our model draft was you could not do less than was already existing in international law. So if you think of the Torture Convention or the Genocide Convention as sort of baselines, you're not going to accept, I hope, as a member of civil society or an academic, any treaty that does less than those treaties to establish jurisdiction, to give jurisdiction to the ICJ, potentially to create a monitoring mechanism like the Torture Committee or some of the other committees. The Genocide Convention is old, so there's no committee, but the Enforced Disappearances Treaty, which is more modern, has a committee. And so our feeling is you should not allow this treaty to be watered down so that it gives less than what we have in existing instruments. Now, can we get more than we have in existing instruments? That's a good question. The Commission did sort of do some creative language on prevention. And one of the things that is potentially a very exciting part of this treaty is that it doesn't just punish, it has obligations of prevention. But what we have to make sure is that the dispute settlement clause, right, gives rise to the kind of erga omnes standing that we have in the genocide cases, like Gambia versus Myanmar or some of the other cases. So I think there are going to be, for the academics like me and the international law nerds, there's going to be a lot of like digging into treaty design, because we want a strong treaty that has good bones. And then for many people in civil society who are focused on particular crimes, crimes against the disabled, crimes against the environment, crimes against women, crimes against children, they will look to the substantive provisions in a way of the treaty. We've already heard about provisions on slave trade, on environmental crimes, on gender apartheid, on forced marriage. So I think there'll be, we're all going to have to be hyper vigilant for 5 years to make sure that at the end of the day, Charles's nightmare scenario is not realized, and that we don't get a watered down treaty, but we get an instrument that we're really proud of. I heard a lot of great states, including Brazil. Thank you, Victor. Brazil was a strong advocate for moving forward, all while respecting consensus. Many, many other states really popped up and were very, very supportive of this process. It's just hard. State delegates will turn over, civil society people will be getting, turning over. And so it's kind of a marathon, not a sprint. It's a bit of a relay race, but we really have to get this done because it is important, Yale, for victims and survivors. Think of the folks in the North Korean detention camps right now. That's a peacetime crime. 100,000 people, political prisoners, right? There are cases of mass atrocities all over the globe that are simply not within the reach of international law as it's currently constituted today. And we can't forget them, right? That was kind of Elie Wiesel's, to go back to some of your original work, Yale, which is being forgotten. Indifference is the worst. It's the worst crime of all. So we just have to roll up our sleeves and get this done for 5 years.
And I think, Yael, you want to say something before Victor?
No, I'm fine. I think we should attend to also to the question and answers when.
Yes.
But I think you wanted Victor to
Yes.
on.
And Victor, the issue is that some states already seem to be changing position, because maybe now we have seen a lot of political prisoners freed from former President Assad detention facilities. And I would say that most probably Syria in the next rounds of negotiation will not stand anymore with the group of the most restrictive states. So I mean, things can also improve in terms of universality and cooperation in the next few years. What is your take on that?
Oh, that's a very good question. What I can say that I'm optimistic about it. From all the statements I heard during the resumed sessions in 2023 and 2024, and now in November, nobody is opposed the codification of crimes against humanity. Some countries, they believe that they have already national legislation and there is no need for them to have a convention. But nobody says that those crimes shouldn't be punishable. So the question is that this convention is meant to be applied by domestic courts, and then it's a missing component of the complementarity principle with the international tribunal. So even if for countries which are parties to the Rome Statute, it will be useful because we have more instruments to really apply the principle of complementarity. And for those countries which are not parties to the Rome Statute, anyway, it's a good instrument for their national enforcement of the prevention and punishment of crimes against humanity. I believe when to your question about immunity, so I feel the obligation to reply because it's a very sensitive question for many countries, and it's no secret if you read the Brazilian written comments that we sent to the Secretariat of the United Nations in December 2023. After the first resume session, we made extensive comments on the International Law Commission's draft articles, and our position is that nothing in the article should be interpreted as affecting the immunity of state officials from criminal foreign jurisdiction. And I think this takes in account that it is a convention that will be applied by national courts, and that many states also will feel more comfortable with the convention if this is taken into account. Of course, we know that there may have there may be different views in this respect, but that's our national position that I can express right now.
Thank you, Victor. There is a question in the Q&A on ecocide. So I don't know if Bieta, you want to be the one taking on it. Of course, I have a strong opinion, but I think you are the expert today, Bieta.
Thank you. Yeah, I will be happy to answer any questions on ecocide, and I'm sure David, you and Layla will fill in where my answer is wanting. The particular question that you are, is it the what about ecocide as a crime against humanity? Yes, okay. So my understanding of ecocide is that the victim in ecocide is the environment itself, which has the advantage of not having to center human beings or to protect the earth for its own sake, and not only for the effects that it has on humans, which is, I guess, just allowing us to live at all. Crimes against humanity, on the other hand, the defining feature is that the victim will be human beings, particularly civilians. So these are two complementary, interlinked, and related crimes in my mind, but they sort of belong in different buckets in that sense. So the Crimes Against Humanity Treaty, as it focuses on civilians, we won't be able to put a whole new crime with a different victim into it. But I do know that there is an initiative to amend the Rome Statute to add ecocide as a crime there. Avaz is actually supportive of that. We have campaigned on it. We have, also solicited member messages on why we think this is important. It has the advantage of recognizing our oneness with the earth, and it's, in our mind, it's not an either or scenario, but it is one in which we sort of have to bifurcate maybe artificially the difference between human beings and the environment, but the way that we sort of have set up the framework, is how it is. But it is, in our mind, all getting to the same point, in a sense, which is to protect the earth and to protect the environment. And the more means and avenues by which we can do that, the better.
Yeah, I agree with you. And also, one thing doesn't, clash with the other. One campaign doesn't clash with the other. There are a number of questions on the issue of whether we can trust the international community, the United Nations, because of all the impunity in crime scenes like Ukraine, or the frustration of double standards from one of our participants. So I don't know if, Elise, you want to take on this issue of whether we should have still trust in the UN decision-making process,
That's a big question. I guess what I would say to that is there are huge challenges, but we can't give up. This is an opportunity. This system is an opportunity where the more we dig in, the more we have the hope of making the most of it. So I think the only option is to really persevere and seek to make the gains we can make, which doesn't mean that there aren't a lot of blockages and challenges.
Thank you. And maybe, I don't know if Charles wants to add on this. But, there are references here in one of the questions. Professor Larafi speaks about the global South, reluctance to agree upon in the face of widespread violations of international law without punishment, trial, sentence. He refers to the Genocide Convention and other situations in the Middle East and other regions of the world. Of course, the question is for Leila, but I want also maybe Charles to take on this in a global South perspective and maybe elaborate. Oh, we're not hearing you. There's something.
Can you hear me now?
Perfect.
Okay, just very quickly, a couple of points. I just wanted to flag, I agree with Beata on the ecocide point, and I just put in the chat the link to the ecocide panel report. I had a privilege to be part of that conversation there in that process, and essentially we just maybe underline that the crimes against humanity discussion there is slightly different from the war crimes discussion. Because of course in war crimes we're looking at it in the context of the Rome Statute, and that's at the international level as opposed to the horizontal level, which is what we're dealing with here. So there's a fundamental difference, and I think will make a huge impact to have environmental crimes addressed in a future convention like this. And there are precedents for that. I think, David, you mentioned the work of the ILC over many years. At one point, the ILC itself had looked at environmental crimes in the good old days of the draft code of crimes. Secondly, on the wider point about the moment in which international negotiations might take place, I'm very, of course, pleased that the international community decided to take forward the draft articles on the basis of consensus. I think the consensus is interpreted in a manner that I would disagree with, but I think at a political level, it's good that states from all parts of the world are able to participate in the process. We ought to be aware, of course, that there's a moment now of, if you will, proof of the pudding is in the eating, right? The international community faces challenges in terms of compliance with international law, especially from big states. We've seen in one moment permanent members of the Security Council, perhaps if we were playing footsie with international legal standards that are very well established, and the response of the international community from the other side has been quite robust. But we've also seen some instances where permanent members are themselves alleged to be, if you will, supporting, aiding, and abetting, and effectively in complicity with other states that may be violating international law. The argument about double standards in international law is an old one. It's come up in international criminal law, but not just in international criminal law for a long period of time. And I think the best we can do as international lawyers is to accept the reality that lawmaking can have this impact, where you have the most powerful states are able to, if you will, drive the regime that they want. But at this moment, it's important that states from all parts of the world participate in these processes, because ultimately, I think the law that we get is as good as the participation we get from every part of the world. That's not to say that there are not valid concerns in terms of compliance. But what I see as a challenge is you have this big state, if you will, taking the exit ramp. For a lot of states, they can't take the exit ramp. International law is all there is, and the rule of law in international affairs is ever more important. And now is that moment, because we see, for example, the pressure on the International Court of Justice, and the ICJ has responded, but the political organs in New York are not responding. So the rule of law is really centered now around the hope of the principal judicial organ of the UN holding the line until the political winds change. So I'll stop there. It's just to say that I take the point completely.
Very good. And Leila, I'm sure you want to add on this. I know that. Go ahead.
No, I was just thinking about what Charles said, and I think, and there's a question about what's happening in the Middle East right now. And one of the delegates that was the most profoundly committed to advancing this treaty was Palestine. The state of Palestine and its delegates were resoundingly committed in every single meeting. They brought along so many of the Arab states that had opposed it, and they would say in every single one of their interventions from the floor, our people are suffering from these crimes, which is why we are recommitting to the principle that nobody should have to suffer from the commission of these crimes. It was such an extraordinary thing to see, and the same with Ukraine spoke very movingly. Many, many states spoke of their personal, but particularly Palestine. Their delegation is really extraordinary. And I think what Charles is saying, look, we're in a period of transformation where old structures are breaking down down and new structures are emerging, but we can't sort of see the outlines of the new structures yet. And the 1990s were like that. And what you need when that's happening is, what are my core principles? What's my North Star? If I'm trying to discern the path forward, right? I want a path forward that's positive and will bring more peace and security, not less peace and security. And I think as we do see some of the old structures under stress, transforming, I think the key is then to just get our core values and our commitment together to produce something better. You saw that in the 1990s. I was lucky to be there at Rome with David. We were a little younger then, but you saw as the Berlin Wall crashed and the Soviet Union dissolved and the international community, there were terrible wars that broke out, Bosnia, the genocide in Rwanda, but there was also this commitment in the 1990s to build the ICTs and the Rome Statute. And I think we're in a similar period where we're seeing these horrible wars around the planet, and we have to commit to doing something about it. And this is one of the tools, only one, it's only one of the tools, but it's a tool.
Thank you, Leila. Before that, I give the final word to Yael and Victor, please, Bieta and Elise asked me for the floor. There are a couple of quick answers to questions. First of all, one question, where do you consider torture by non-state actors fit? It's already included in the definition. We don't need to change the definition. Torture is not anymore only for state actors. In Article 7 and in the draft articles, it covers the torturers when they are non-state actors, if they have the control over the victims. Then there is another question on the issue of ecocide in Ukraine. And this is something where there is already an ongoing investigation by Ukrainian bodies, because they have the crime of ecocide in their penal code. But on the other side, we know that, and I can safely say it, that there are ongoing investigations by the ICC prosecutor also for this type of situations like Kherson and Zaporizhia and the dam, the Nova Kakhovka dam, maybe not in terms of ecocide, but in terms most likely or other inhuman acts. So we have to see where the jurisprudence will go, but what we have seen is a little bit only the tip of the iceberg at the ICC. There is much more going on that has already gone and might have been sealed due to reasons of, augmenting the chances of arresting fugitives. I don't know if we want to have a final word. I don't want to take too much time here. Yael, you have the right to that, but maybe Victor, Elise, of course. Elise, absolutely.
I just wanted to add that I put it in the chat, but there is a website, CAHtreatynow.org. Let me make sure I've got that right. CAHtreatynow.org that has a wealth of resources on the treaty process in general and also the gender justice proposal. So I would encourage everyone to take a look.
Fantastic, fantastic. And we are all co-signatory of the statement that's CGI champion. Sorry, I cannot pronounce the acronym. I have a problem with it. Victor.
My final words, just to thank you. I feel very privileged to have participated in this webinar. And when it comes to the power that member states have, that if I'm not mistaken, Bieta mentioned, actually, we, as member states, we are accountable to our societies. We are chosen, we are elected by our societies. So you have the power. When we were preparing our statements, our written comments, we were listening to the civil society and we learned a lot. And they certainly had an influence on the positions we took. So you also have the power and you have to keep the pressure on us. Of course, we play different roles. As member states, we have to negotiate, we have to make compromises. And it's natural for the civil society and academia to push for the best. And that's what we will try to achieve. But what we want to achieve, it's a convention that's universal, that will be effective, that will be applied by every country. Thank you.
Thank you, Victor. And Bieta, do you want to add something before the end?
I guess the only thing is, if you're interested in, more of Avaz's work, if you sign any of our petitions, you will be apprised of the work that we're doing. So please join us.
Very good. So the people have the power, as Victor told us, and we hope to be the people of every state that takes a positive decision on the Crimes Against Humanity Convention. Yael, the floor is yours.
Thank you, David. And thank you, everyone. This has been absolutely wonderful. I think it's a good idea to have this recur, this particular panel, or exactly the topic, every year. So we review in a year what we said today and how far we went together in civil society and governments to fulfill this amazingly important treaty. And then again in 89, in 88, in 2018, I won't be then, but in 28 and 29, until we finally have the golden treaty that we want to create together. Before I invite you for last words, I would like to share with the audience and you that we have, in January 2nd, we start with the webinar on women in the historiography of Haiti, both oral and written. January 7, we have a webinar on the Victory Day of Cambodia. January 15, connected to the International Day of Education, we have a webinar with initiatives to educate Afghan mothers how to educate at home their daughters and children. I can't tell you how much I'm excited about each one of these. And on and on. It's important that each one of you know that our webinars are utilized by professors around the world as materials for study for their students. So you're not just limited to the close to 200 people registered today, but your words will make a whole lot of difference, I'm sure, in the hearts of many young people and in the condition of many older people and in between. And we promised you that you'll have last words, each one of you, before we leave today. So let's go from the last to first. Charles, your last words for today. You have to unmute.
You can hear me?
Yes.
Can you hear me now? Okay, just to say thank you so much for organizing this event and for including me. Well done, thank you.
We will get back to you, don't worry. Yeah. Okay, Elise, please.
Just
Oh,
appreciate.
no, actually, it's Beata, but forgive me, Beata. Go ahead, Elise.
To say appreciation, and I'm excited to be able to broaden the network of people who are familiar with these issues, and we need to keep going with that. So thank you so much.
Wonderful. And Beata, please.
Yeah, just thank you to all the panelists and to Dr. Danielle and Dr. Catton for organizing this, and to everyone who's attended. I hope this was really informative, and yeah, have a happy new year.
Perfect, thanks. Victor, governments.
Well, thank you very much. It was really a pleasure to participate. I learned a lot today, and please, everybody, count on Brazil's effort to achieve the convention.
Yes, and of course, Leila.
Likewise, I would just add to the chorus of thank you, Yael, and thank you for the important new work that you do with respect to victims and survivors. And
Thank you, dear. And David, your last word.
Well, there is a lot of work. We have time until 2029 and not the early 2029. And I think this was purposely decided because the United States of America is one of the 99 sponsors with Brazil, Sierra Leone, and many other states of this wonderful resolution. And maybe in 2029, maybe they will be back as a co-signatory in support of whatever outcome will be there. We'll see what will happen. We will see what will happen.
Thank you so much. And thank you for our wonderful audience and for everyone who's going to learn from the recording. Thank you again.
Thanks so much. Take care.
You
Thank
too.
you.
Thank you. Bye-bye.
Bye-bye.
Bye-bye. Thank you.